Thank you for joining us for today's Women in Nuclear Law Initiative webinar, Nuclear Law 101. People from around the world have registered to participate in this event. To ensure a stable connection and considering the large number of attendees, your video and audio functions have been disabled. You can still actively participate in the discussion by expressing your views, sending us your comments, and asking questions using the Q&A feature. Please note that we may not have enough time to take all of the questions online, but we will do our best to treat them after the event. Today's discussion is being recorded, and the recording will be made available online in the near future. I am delighted to introduce our first presenter, Ms. Perry Lynn Johnson. Ms. Johnson is the Assistant Director General and Legal Advisor of the IAEA. Perry has over 31 years of legal experience in the United Nations system. In 2011, she became the first female legal advisor and director of the IAEA Office of Legal Affairs, and is the longest-serving legal advisor in the history of the IAEA. Perry, the floor is yours.
Thank you so much, Robin. It's a pleasure to be here with all of you for this webinar on Nuclear Law 101. And in the next 15 minutes, more or less, I'm going to be giving you a very brief overview of nuclear law from the IAEA perspective with a focus on treaties and standards. Next slide, please. So what is nuclear law? We defined it here in the IAEA as the body of special legal norms created to regulate the conduct of legal or natural persons engaged in activities related to fissionable materials, ionizing radiation, and exposure to natural sources of radiation. And the primary objective of nuclear law, as you see on the slide, to provide a legal framework for conducting activities related to nuclear energy and ionizing radiation in a manner which adequately protects individuals, property, and the environment. And a basic feature of nuclear law is its focus on the benefits of nuclear technology while minimizing the risks. Next slide. So what does nuclear law cover? Basically, it's four main branches, and this is what I'm going to be talking about: safety, security, safeguards, and liability, which we say in the IAEA, it's the 3S plus L. Next slide. Before jumping into those four pillars, I would just like to state that, of course, this nuclear law has been developing at two levels in parallel. So at the international level, it's all about the international instruments, and I'm going to be focusing on that. And at the national level, these international obligations are incorporated into national law. Next slide. So we're going to be starting with the International Legal Framework for Nuclear Safety. And at the core of the International Framework for Safety are four key treaties. And these treaties are adopted under the auspices of the IAEA, and all were adopted following Chernobyl, the Chernobyl accident. First, the Convention on Nuclear Safety. It is the legally binding instrument to address safety of nuclear installations, seeking to ensure that such installations are operated in a safe manner. The CNS is the cornerstone of the International Legal Framework for Nuclear Safety, and it was adopted in Vienna on 17 June 1994, and it entered into force just 2 years later on 24 October 1996. All countries except one currently operating nuclear power plants are party to this convention. But you don't have to operate a nuclear power plant to be a party. In fact, many are parties who are neighbors to those operating a nuclear power plant because they also want to have a seat at the table. I want to turn now to the Joint Convention on the Safety of Spent Fuel Management and on the Safety of Radioactive Waste Management. It's the sister convention to the CNS, and it's focusing on, as its name says, it's focusing on the back end of the fuel cycle. It was adopted in 1997, and it entered into force on 18 June 2001. It's the only international legally binding treaty to address the safety of spent fuel and radioactive waste management. And like the CNS, it's representing a commitment by the parties, by the contracting parties, to achieve and maintain a high level of safety in the areas covered by the convention. Both the CNS and the Joint Convention are called incentive conventions, and this means they are designed to encourage consensus and participation. A key feature is what we refer to as the peer review process. And this is contracting parties have to report on their obligations. And every 3 years, these are peer reviewed at meetings held here in Vienna. In fact, the Joint Convention review meeting is ending this week. I want to turn now to the Early Notification Convention, moving now into the emergency preparedness and response area of nuclear safety. So the Early Notification Convention aims to strengthen the international response to nuclear accidents by providing a mechanism for rapid information exchange in order to minimize transboundary radiological consequences in case of an accident, with a release of radioactive material occurring or likely to occur. And the Early Notification Convention, again, has kind of a sister, which is the Assistance Convention. Because if there is an accident, one, you have to notify, but then, of course, we want to make sure there's international assistance available. And so this Assistance Convention strengthens the international response to a nuclear accident or radiological emergency, irrespective of the cause. And essentially, it's establishing an international framework to facilitate prompt request for and provision of assistance. And the whole framework is promoting, facilitating, and supporting cooperation amongst the state parties and the IAEA to that end. These two conventions are supplemented by what we refer to as operational arrangements that provide the basis for the International Emergency Preparedness and Response Framework. And at its center is the IAEA's Incident and Emergency Center, which serves as the global focal point for international emergency preparedness, communication, and response to nuclear and radiological incidents and emergencies, regardless of the cause, whether it's an accident, whether there's negligence, or whether there's a deliberate act. These 4 conventions are complemented by a suite of safety standards. These are technical recommendations and standards that are adopted through the IAEA statutory function that's enshrined in our statute, based on consensus decisions of our Board of Governors. So it's reflecting what the membership agree as a high level of safety. So an international consensus. And we say that these safety standards are non-binding, and I want to be clear on that. They are mandatory for IAEA activities. They're voluntary once adopted at the level of the Board of Governors, our primary executive organ here at the agency, but they become binding for states once they're incorporated into their national law. And as the Director General says, most states are complying with the safety standards. And you see on the slide, we're highlighting one, which is the technical, the transport regulations. You see that there. And I highlight that because these were adopted, the first effort was 1961, but they form part of the UN recommendations for the safe transport of dangerous goods. And essentially, the entire world is complying with them because it's the only way you're going to be able to transport nuclear material. So I also would like to highlight, before moving out of safety into the next branch of nuclear law, that there are 2 codes of conduct. There's a code of conduct that's dealing with the safety and security of radioactive sources, and there's the code of conduct that's dealing with the safety of research reactors. These are non-binding codes of practice, as the title says. They were adopted through our Board of Governors, the primary executive organ of the agency, and the General Conference, like the General Assembly. Every member state is there. And these were adopted. It's interesting to understand how it all fits together, but essentially they're filling gaps for the sources, for the radioactive sources. This was adopted because the Convention on Physical Protection of Nuclear Material, which I'm going to talk about in just a moment, is limited to nuclear material. So sources aren't covered, hence the code of conduct. And research reactors. This was adopted because, as I mentioned, the CNS is focused on land-based nuclear installations, power plants, not research reactors. This is how the international legal framework continues to evolve. So these codes of conduct, briefly, they are about developing and harmonizing policies, laws, and regulations in the areas that are covered, but they don't have a peer review mechanism. And since they're non-legally binding, the Code of Conduct on the Safety and Security of Radioactive Sources allows political commitments. So it's another option in international lawmaking. And to date, we have 153 states that have expressed a political commitment to abide by that Code of Conduct. I'd like to move now to the next slide and turn to nuclear security. So in this branch of nuclear law, we're talking about something different than safety. It's about the prevention, detection, and response to criminal or intentional unauthorized acts that are involving or directed at nuclear facilities, nuclear material, other radioactive material, associated facilities, and activities. So, malicious acts. It's important to note that in this area, which is considered part of the global anti-terrorism framework, the IAEA is not the only actor. There are many actors in the United Nations, its specialized agencies, including the UN Security Council as well, that have all contributed to what's known as the global terrorism framework, anti-terrorism framework. Within the IAEA, the main treaty in the area of nuclear security is the Convention on the Physical Protection of Nuclear Material. And it was amended in 2005. That amendment came into force in 2016. And the CPPNM and its amendment are the only international legally binding undertakings in the area of physical protection of nuclear material. And the amendment also brought in nuclear facilities for peaceful purposes. So with the amendment, we have expanded the obligations of the parties in the area of physical protection. We have brought in new offenses in terms of criminalization of offenses, and we've expanded international cooperation to cover those new offenses, such as smuggling and sabotage of nuclear facilities. So as I mentioned already, there's a code of conduct on radioactive sources that forms part of the nuclear security framework. And I explained why, because the Convention on Physical Protection of Nuclear Material is limited to nuclear material, as the title says. But I also want to point out, like in the case of safety, we have a suite of guidance. It's called the Nuclear Security Series. And this is guidance on all aspects of nuclear security. So it works like the safety standards, but we have a separate, group of states that meet and so on, open to all of our member states. And that is how this guidance is developed for nuclear security. An important publication is on the slide, and this is Nuclear Security Recommendations on Physical Protection of Nuclear Material in Nuclear Facilities. It's otherwise known as MCERT 225 Rev 5. And it's what gives member states more practical, technical guidance on how do they do it. How do you do the physical protection of nuclear material? And I'd like to turn now to safeguards, which is the next branch of nuclear law. The third S, I said 3S plus L, so this is the third S. We are well known by our safeguards work. I think most well known by our safeguards work. And it's one of the core functions of the agency as enshrined in the statute. And it's, of course, as you all know, it's in the aftermath of World War II and so on. So safeguards is about preventing the diversion of nuclear material from peaceful activities to prescribed purposes. And this is done by verifying that states are abiding to their obligations under their safeguards agreement, and that the nuclear material in their states is being used for peaceful purposes. So the Non-Proliferation Treaty, the Treaty on the Non-Proliferation of Nuclear Weapons, to use the full name, otherwise referred to as the NPT, which entered into force in 1970, as well as a number of regional treaties establishing nuclear weapon-free zones, require the conclusion of safeguards agreements with the agency. To date, we have 191 states with safeguards agreements in force. And the safeguards activities are carried out based on 3 types of agreements. Item-specific agreements are with the 3 non-NPT states, Israel, Pakistan, and India. Comprehensive safeguards agreements are applied for 183 states, pursuant to the NPT, as I just mentioned, and also weapon-free zone treaties. And that's basically the world. And what's remaining? What's remaining are the voluntary offer agreements, and these are applied to the 5 nuclear weapon states under the NPT, and you know who they are: US, Russia, China, UK, France. These safeguards agreements are complemented with what's referred to as additional protocols. And these additional protocols give our inspectors, so we have an inspectorate here that's doing the verification work, additional information and additional access. And as of today, 143 states have brought into force additional protocols, including 137 of those states have comprehensive safeguards agreements. Now I'm turning to the final pillar, L, which is nuclear liability. And very briefly, this branch of nuclear law, it's all about compensation, a mechanism for compensation for damage, including transboundary damage, caused by a nuclear incident at a nuclear installation or in the course of transport of nuclear material to or from an installation. This area of nuclear law has created a special international regime for civil liability for nuclear damage. It provides prompt and meaningful compensation for third parties and a clear identification of the liable person, which is the operator of the nuclear installation. Liability, this regime, it's a number of multilateral treaties. Some are under the auspices of the IAEA, called the Vienna regime. Some are under the auspices of the OECD NEA, referred to as the Paris regime. And they've been adopted since the early days of the nuclear industry, since the 60s. After Chernobyl, they were modernized. And they all have common principles. And I'm not going to go into the details of those here, but I just want to sum up the main thrust of the reason we have this regime, which is to establish uniform rules and mechanisms for liability and compensation, to ensure, as I mentioned, prompt access to meaningful compensation, minimizing prolonged and expensive litigation, and avoiding the complexities of what's otherwise called tort law, where parties could seek to have jurisdiction in certain places, so-called forum shopping. It avoids that. It makes it clear what state has jurisdiction and what courts have jurisdiction. And it also assures recognition and enforcement of judgments. And the bottom line is that the whole regime, this special regime, is to provide legal certainty for the nuclear industry. There's much more information on all these 4 branches of nuclear law on our website, iaea.org. And I thank you for your attention and look forward to engaging with you during the course of the webinar. Thank you.
Thank you so much, Perry, for those insights. Now I would like to introduce Ms. Kimberly Nick, who is the head of the Division of Nuclear Law at the NEA. Ms. Nick joined in the NEA in 2014, and prior to this, she served as legal counsel and attorney at the U.S. Nuclear Regulatory Commission. Kimberly, the floor is yours.
Thank you so much, Robin, and good morning, good afternoon, good evening, everyone. It's my pleasure to be here with all of you today for this very first webinar for the Women in Nuclear Law Initiative. I'm so grateful to my co-panelists, Perry and Lisa, for being able to join us. I think this is a fantastic lineup that we have, and I'm grateful for all of the many participants who've joined us online. So I am here with all of you today to discuss the Nuclear Energy Agency, and particularly its role in international nuclear law. Now, the NEA was established within the framework of the OECD, and according to Article 1 of its statute, the agency is charged with promoting cooperation between member countries for the development of the production and uses of nuclear energy for peaceful purposes. Now, when I say that the NEA was formed within the framework of the OECD, what exactly do I mean? Well, you can see on our screen that the OECD has a broad mandate spanning numerous disparate topics. You'll see, however, that there are a few topics missing from this list of OECD work, including energy in general and nuclear energy in particular. And that's because these are addressed by separate entities that are within the OECD family. And one of those entities is, of course, the Nuclear Energy Agency. Now, NEA membership today totals 34 countries from Europe, North and South America, and the Asia Pacific region. Together, NEA member countries account for approximately 82% of the world's installed nuclear capacity. Now, in addition to our member countries, the NEA interacts and works cooperatively with other countries and organizations. Within the OECD family, we work with, in particular, the International Energy Agency. We also work very closely with the European Commission and the IAEA, both of these relationships going back largely to the founding of the NEA. On occasion, interested countries, including NEA members, partners, and non-members, decide to develop special international initiatives to approach areas of special interest. They find that the NEA, with its deep technical expertise, flexible and responsive framework, and key position as an enduring framework for cooperation, to be a vital partner in supporting, managing, and sustaining the activities of these initiatives. Currently, the NEA serves as the technical secretariat for the Generation 4 International Forum, or GIF, the International Framework for Nuclear Energy Cooperation, or IFNEC, and the Multinational Design Evaluation Program, or MDEP. At other times, there are countries and economies that can be invited to participate in the work of NEA committees and other main bodies. These countries and economies are referred to as partners, and their participation enables the exchange of best practices, standards, and expertise. In particular, 5 countries have been designated as key partners of the OECD, and that's Brazil, China, India, Indonesia, and South Africa. We do work with the nuclear industry, and that work is transparent. And the work is often done through memorandums of understanding that are approved by the NEA Steering Committee. Some prime examples of our work are those with the World Nuclear Association, WANO, and EPRI. Increasingly, we have been seeing the importance of working with academic and research institutions, not only for collaborative scientific purposes, but also to nurture the next generation of nuclear professionals. Now, why do we have all of these relationships? Well, it's because we recognize that there is no single body, organization, or group that can do it all. These relationships help us to enhance our efficiency, identify areas of synergy, coordinate our efforts to ensure complementarity, clarify roles, and importantly, to avoid duplication of effort. Now, as regards duplication and coordination, we often receive questions about how the NEA compares to other organizations, in particular organizations like PERI's at the IAEA. Now, obviously, the NEA and the IAEA address many of the same subject matters, but we don't have the same audience. NEA member countries include those nations with the most highly developed nuclear technology programs, and the conversations between our member states and the IAEA's member states can vary. As outlined very clearly by Perry just now, the IAEA has a very important role in establishing a framework that can be applied by all countries at every stage of their development. The NEA takes that standard framework and goes a bit further, focusing on discrete technical issues and problems specific to our highly experienced members. In-house, the NEA's activities are governed by the Steering Committee for Nuclear Energy. The steering committee provides oversight to ensure that the NEA carries out its activities in a manner that is in conformity with the provisions of the NEA statute and OECD Council decisions. The policies and overall guidance under which the NEA operates are set by the steering committee, and key areas of work are overseen by standing technical committees. These standing technical committees are established by the steering committee. These committees efficiently carry out the NEA's program of work and strengthen the NEA as a key international instrument of cooperation. Committees are composed of member country experts and constitute a unique feature and an important strength of the NEA, providing flexibility for adapting to emerging issues and helping to achieve consensus rapidly. The day-to-day work of the NEA is facilitated by a highly expert staff that serves as the secretariat to the steering committee, the standing technical committees, and their subsidiary bodies. These experts often serve for limited periods and then return to their original organizations in their home countries. The NEA staff is overseen by our Director General. The NEA has 8 standing technical committees in areas such as nuclear safety, radioactive waste management, and in particular for our purposes, nuclear law. The NEA's committees bring together top government officials and technical specialists from NEA member countries and strategic partners to solve difficult and technical problems, carry out research, develop consensus opinions, establish best practices, and promote international collaboration. For this work, the NEA relies on approximately 74 working parties and expert groups. Now, looking in particular at the Standing Technical Committee in the area of nuclear law, we have the Nuclear Law Committee, for which my division, the Division of Nuclear Law, provides secretariat services. Underneath the Nuclear Law Committee, there are 3 working parties that address more detailed issues at a working level. These groups are the Working Party on the Legal Aspects of Nuclear Safety, or WP-LANS, the Working Party on Nuclear Liability and Radioactive Waste Disposal Facilities, or WP-LDF, and the Working Party on Nuclear Liability and Transport, or WP-NLT. And I will just pause here to mention that Lisa Teal, who is on this webinar with us, is the chair of our Working Party on the Legal Aspects of Nuclear Safety. So this is one key way that you see us as an international organization working in close collaboration and partnership with our member countries and their experts. The Nuclear Law Committee and our working parties work together to help the NEA achieve its nuclear law objective, which is to help create sound national and international legal regimes required for the peaceful uses of nuclear energy, including as regards nuclear safety, international trade in nuclear materials and equipment, public engagement, issues of liability and compensation for nuclear damage, and to serve as a leading center for nuclear law information and education. To achieve this goal, the NEA will assist our member countries in the development, strengthening, and harmonization of nuclear legislation and regulation in areas such as nuclear safety, radioactive waste management, and environmental law, contribute to the modernization of the international nuclear liability regimes, and encourage the strengthening of treaty relations between interested countries, and to collect, analyze, and disseminate information on nuclear law generally, and on topical nuclear law issues in particular. So what does that look like in practice? Well, it all comes together in our program of work, where it shows that we will, to strengthen, develop, harmonize nuclear legislation, we will work on issues such as small modular reactors and other innovative and advanced technologies. In application, interpretation, modernization of the nuclear liability regimes, we'll host workshops that address in-depth nuclear liability issues and publish reports. We'll promote adherence to nuclear liability conventions and work to transpose nuclear liability principles in national laws. And we'll prepare practical and informative documents such as tables to compare legal approaches. In the analysis and dissemination of nuclear law knowledge and information, We publish twice each year the Nuclear Law Bulletin, and as well country reports on legal frameworks for nuclear activities. I hope many of you on this webinar are familiar with the Nuclear Law Bulletin, and if you're not, please Google it or let us know, and we can make sure that you have access to it. It's available for free online and has been published continuously since 1968. We support the NEA Delegated Authority's depository functions, meaning that we provide secretariat services to the contracting parties to the Paris Convention. As Perry mentioned, the OECD is a depository to the Paris Convention on nuclear third-party liability. So we work with those contracting parties to the Paris Convention, including assisting them in achieving ratification of the 2004 protocol and overseeing all follow-on activities. We also assist the CPPCs in interpreting and reviewing the Paris Convention. For example, a new recommendation adopted in 2016 concerning the application of the Paris Convention to nuclear installations for the disposal of certain types of low-level radioactive waste. And finally, in training and education in nuclear law, we hold, for example, the International School of Nuclear Law and the International Nuclear Law Essentials. Hopefully, as well, many of you are familiar with these programs. Particularly, many of you may have participated in them, and if so, welcome to all of our alumni here. We work very closely with people like Perry and Lisa on these programs, and hope for those of you who we haven't had the pleasure of seeing at these programs that we'll see you there in the future. We also published Principles and Practice of International Nuclear Law, again, with articles by Perry and Lisa in this. It's a textbook for free online that gives you all of the information you could possibly want to know on the types of information we're presenting to you here today. And as well, we are the Secretariat to a global forum on reestablishing nuclear law education, working with academics from around the world to try to reestablish the teaching of nuclear law in law schools and universities around the world. So I'd like to conclude with a practical example of what collaborative work looks like at the NEA in the area of nuclear law. So as I mentioned, we provide secretariat services to the Nuclear Law Committee, or the NLC. Our NLC meets once a year to discuss topics of importance, to consider priority issues, and to address our program of work. Let's say at one of our meetings, the NLC decides that it wants to look into the frameworks for legal challenges to nuclear safety across all NEA member countries. Well, that's great, because it's just the type of thing that the NLC Working Party addresses, in particular, our Working Party on the legal aspects of nuclear safety. The NLC then tasks the WP Lands to address this question, for which it sets out a plan to address the issue, which then gets approved by the NLC to make sure that all of the right questions are being asked and that all of the right topics are being addressed. Perhaps at that point, an extensive survey is circulated to all of our member countries to fill out to help inform a future report. This is incredibly important because as smart and as capable and as competent as all of the people in the Division of Nuclear Law are, they cannot possibly be expected to know the intricacies of the national laws of all of our member countries on discrete topics. So what we need to do is work hand in hand collaboratively with our experts in the member countries to answer these questions to ensure that we have all of the proper information to feed into a report. At that point, the Secretariat and the country's subject matter experts work together to analyze the responses to the survey and to write a report. The report would then be approved by the Nuclear Law Committee, and once it's approved, it would likely be made freely available online for the entire world nuclear law community, not just the members of the NEA, but for anyone who's interested in this topic. Ultimately, this is how our flagship report on legal challenges related to nuclear safety came about. And what we're working on right now quite diligently is a 5-year update to our 2019 report on legal frameworks for long-term operation of nuclear power reactors. So I hope this helps to very quickly explain the role of the NEA generally in the international nuclear world, and in particular, the role that we play in international nuclear law. And I look forward to taking your questions at the end. Thank you very much.
Thank you so much, Kimberly. Now I would like to introduce Ms. Lisa Teal, Vice President of the Legal and Commission Affairs and Senior General Counsel at Canada's nuclear regulatory body, the Canadian Nuclear Safety Commission. Ms. Teal has extensive experience and expertise in nuclear regulatory law, both at the national and international levels, serving as lecturer, mentor, and leader in activities and bodies at the NEA, IAEA, WNU, and International Nuclear Law Association, among others. Lisa, the floor is yours.
Thanks so much, Robin, and hello, everyone. I'm super happy to be here. And you've heard from Perry and from Kimberly with respect to the international organizations' roles in international nuclear law, in coordination and cooperation, in setting standards, best practices across member countries, and efforts toward harmonization. I am here to provide a perspective on nuclear law from a national perspective. This is where safety, security, safeguards, and liability is operationalized in national law, implementing the international law and standards within national frameworks and governmental structures. So I hope to set that context, how international law is operationalized in national law, using the example of Canada, of course. So if we start from the Handbook on Nuclear Law, which is a great resource, one recognizes first that the legal norms for the regulation of nuclear energy are part of a state's legal system. And so we all have different legal systems, and those are the legal systems where the regulation of nuclear energy happens. Nuclear law is both international and national, as you heard from Perry. But you'll see on this slide, the safety, security, and safeguards pieces are done actually at the state level. So the Convention on Nuclear Safety, for example, notes that the responsibility for safety rests with the state that has jurisdiction. But the convention also notes that importance of international cooperation. Similarly, with the Convention on the Physical Protection of Nuclear Material and Nuclear Facilities, responsibility to establish the regime within a state rests with that state, and that includes the international transport of nuclear material as well. And you'll see it is to national law that one must look to find how a state does nuclear regulation and oversight in that state, and also to how states may interact with each other and with international bodies. So here's the Canadian Nuclear Safety and Control Act is Canada's regulatory legislation. And I just note the preamble to the legislation notes the national and international interest in regulating the development, production, and use of nuclear energy, and that at least Canada recognizes it's in the national interest to have consistent national and international standards. And so you see that national and international piece in the national legislation. The NSCA creates the Nuclear Safety Commission, and it separates out the regulatory function from nuclear energy development. And you'll note that both the IAEA and the NEA have purposes to further the development and production of nuclear energy. National nuclear regulatory bodies are separate from that development. Regulatory independence, in fact, is key to insulating nuclear safety decision-making. And we see that in the Convention on Nuclear Safety that Perry mentioned, which requires effective separation between the functions of the regulatory body and the functions of those entities responsible for development. And similarly, in the Joint Convention, that other incentive convention reflects that each contracting party shall take the steps to ensure effective independence of the regulatory function. So that's one big difference from the international and the national level. The mandate of the Canadian Nuclear Safety Commission is to regulate, and to regulate in order to prevent unreasonable risk to the environment, health and safety of people, prevent unreasonable risk to national security, and to achieve conformity with Canada's international obligations. Also, the Nuclear Safety and Control Act gives the regulator the mandate to disseminate objective scientific, technical, and regulatory information. So how do national nuclear regulators regulate? And so the Convention on Nuclear Safety requires that a national framework shall provide safety requirements, system of licensing, and the prohibition of operating without a license, system of inspection, assessment, enforcement. And also INSCIRC 225, which was the security recommendations that Perry mentioned, they also give very good guidance on what measures the state should take within the national law to establish an appropriate security framework. So the point here is that international nuclear law doesn't prescribe the manner that states regulate nuclear activities for safety and security. States parties do it on their own within that international framework. So how the CNSC regulates licensing under the NSCA, and with that setup of the regime that includes conditions of licenses, compliance, enforcement, all of those regulatory functions prescribed by the CNS. Regulation making. The Commission has the power to make regulations which are subordinate legislation in Canada. They apply to everyone in Canada. Harmonization and standardization can happen here. For example, this is where Canada has incorporated the IAEA transport regs, for example, and adapted them to the Canadian context in our packaging and transport regs. Similarly, we incorporate nuclear suppliers group guidelines for export controls in our non-proliferation import and export control regs. So the requirements are meant to be performance-based, technology neutral, and this can facilitate harmonization with other jurisdictions. I noted vendor design review there, just as a piece I won't talk about in the interest of time. So national regulators regulate, they also cooperate. So how do states and their regulatory bodies cooperate? Certainly the international instruments recognize the importance of regulatory cooperation among and between regulators and with international bodies. That's noted certainly in the CNS, the Convention on Nuclear Safety. Nuclear cooperation agreements. These set out the parameters for state-to-state sharing of materials, technology, and information for civilian peaceful energy production. And under NCAs, the regulatory bodies are usually the authorities to do the arrangements to implement those cooperation agreements. Bilateral cooperation in safety and security, that happens between and among regulators. There's multilateral cooperation, both IAEA and NEA related. Regulators have fora for their own regulatory cooperation. There are several bodies that do that. And I'll mention peer review as well. Perry mentioned the importance in the incentive conventions of peer review among contracting parties to those conventions, where states show and demonstrate how their national structures comply and adhere and implement the international treaties and conventions and standards. The IAEA also has an integrated regulatory review service, and that peer review has a special place in nuclear regulation. Those IRRS peer review missions provide an opportunity for experts from all over the world, as coordinated by the IAEA, making recommendations to states with respect to improvements to their regulatory regimes as a function of their compliance with safety standards with respect to regulatory structures. And that's in a GSR 1 is one of the IAEA guidance documents that's really important in that regard. So how Canada and the CNSC cooperate. Canada is a member of the IAEA, the NEA, the Nuclear Suppliers Group, and other organizations, both formal and informal. Canada has nuclear cooperation agreements with many countries and the CNSC has the administrative arrangements pursuant to those nuclear cooperation agreements as the appropriate authority for the implementation of that cooperation. The CNSC is also the competent authority under many of the international instruments to which Perry made reference. For example, it's the competent authority for the early notification and assistance conventions. It's the point of contact and the resource for many of those international instruments. CNSC is also a member of INRA, the International Nuclear Regulators Association. I'll end on this point. How the CNSC also cooperates bilaterally and multilaterally with other regulators. The statute, the Nuclear Safety and Control Act, empowers the CNSC to enter into arrangements with any regulatory agency or department of a government or any international agency. So this sets up a framework for that cooperation between the CNSC and other national regulators. And we do so through memoranda of understanding for regulatory exchange of information and operating experience. And we do so with respect to some specific programs of work under memoranda of cooperation. And I will note that MOC framework for the exchange of information and sharing of best practices. I'll give the example of the MOC on advanced reactor and small modular reactor technologies that is between the US Nuclear Regulatory Commission, the Canadian Nuclear Safety Commission, and the UK's Office for Nuclear Regulation. And that MOC sets up a structure for the sharing of experience in reviewing advanced reactor designs in the pre-licensing work, but also in the training and research and in the sharing of joint reviews where that makes sense. And this is collaboration meant to enhance safety and agility in each country while also maintaining that regulatory independence. It's a state responsibility to regulate nuclear in that state. And so it's a national sovereignty issue that's important to retain. But in order to avoid duplication and get toward harmonization, this is one of those instruments that facilitates that kind of efficiency and is the way forward as we deal with advanced technologies and reactors. And so with that, I will say thank you for your attention, and I think we will end up having some time for questions, hopefully. Thanks very much.
Thank you so much for that, Lisa. At this point, yes, I would like to bring back all of our panelists for the Q&A session. We've been getting questions throughout these presentations by our audience through the chat. We appreciate your enthusiasm. So I'll start with the first question to Perry. Given the soft law nature of the codes of conduct and transport regulations, are these sufficient or should they be transformed in the future to more hard law requirements?
So safety standards, can you hear me?
Yes, we can hear you.
So it was safety standards and whether safety standards should be transformed into hard law.
Yes, so specifically codes of conduct, transport regulations.
Codes of conduct, okay. So transport regulations, as I mentioned, it's part of our safety standards framework. And as I mentioned, they are in fact brought into national law. And essentially the entire world is complying with them, because you're not going to be able to transport nuclear material without adherence to them. And I was happy to see Lisa's presentation, because she showed us the Canadian regulation that had codified them. Look, so codes of conduct and it's a really interesting question. And I like talking about this because what you're taught in law school is not always the reality in practice. The reality is we need non-legally binding instruments. And without them, we won't be able to move and develop nuclear law to meet the current challenges of the day. Why? Because to agree to a treaty takes political will. Treaty, hard law. To get member states to agree to that, it takes years of negotiation. The amendment to the CPP&M, everyone realized we needed to strengthen physical protection. For years, they talked about here in Vienna, Canada, and all the member states, we need to strengthen physical protection. But it was only after 9/11 that the momentum was galvanized to agree to an amendment, a formally, legally binding amendment to that treaty. But guess what? As I pointed out, it took almost another 11 years before the amendment entered into force. So codes of conduct, because they're not legally binding, it's easier to get consensus around a text. It's easier to get it adopted. And I have to say, this concept of political commitments, it's useful. It's a useful additional tool that we have at the international law making level. Most states have, as I showed you, 153 states for the Safety and Security Code of Conduct have expressed a political will to comply with that. And that means they're bringing it into their national law. When they ask for legislative assistance, which is something we offer to support states in fulfilling their obligations in terms of the international framework, they are actually bringing the codes of practice that they've agreed to adhere to into their national law. So my view and our view here at the IAEA is that there's a really important role for non-legally binding codes of conduct. So that's what I'd like to say on that. Thank you.
Thank you. Lisa, you wanted to add something?
Yeah, I would just say from a national perspective, and when we think in terms of, the transport regs and the importance of nationalizing international standards, they also have to be adapted. And so when you have an international standard, it has to fit within a national regime. And so at a certain point, it is more realistic for the international standard to be relatively high level. When Canada implements the transport regs, for example, it has to allow for the climate in Canada. And so there are, were that to be a hard law instrument, it would be, it would lose something in the translation to a national. So we do want that harmonization, but it also has to be reflective of the realities of national responsibilities.
Yep. Thank you very much. Kimberly, do you want to jump in or okay? All right, well, I'm going to send it back to Lisa for the next question as well. So how crucial is regulatory independence in ensuring the protection of nuclear law and laws?
It is primordial, I would say. And what independence means in practice, I think lawyers can tie themselves in knots about, because there's no question that regulators fit within a state's legal structure. What I think is most important to remember is the reason why regulatory independence is so important, and that's to insulate the safety decisions. So you don't want developers, you don't want political, you want the technical assessment and judgment that's applied of what is required for nuclear safety to be adequately insulated from influence. And that's going to look different in different places and in different structures. But I would say we do not have certainly the three S's, but in particular and most importantly, I would say with respect to nuclear safety, regulatory independence, and insulation of the safety decision making from any kind of other considerations is key, and we can't live without it. And we've seen in studies from the major accidents that have happened, the degree of regulatory independence is front and center. And so I don't think there's much question that it's primordial.
Okay, great, thank you. All right, I'm going to send the next question to Kimberly. One of the attendees has an engineering background with many years of experience in the nuclear industry, and they're very much interested in a career path towards law, especially nuclear law. What education or coursework would you recommend to a new emerging lawyer to start with?
Well, number one, I'd say this is fantastic that nuclear law is so interesting to you at this stage of your career. Transformations into a nuclear lawyer from an engineer can absolutely happen. And I know many, many reformed engineers who have undertaken law studies after they've gone through their engineering work and decided to cross the Rubicon over to becoming a lawyer. And in fact, I have one member of my team at the Division of Nuclear Law who is a reformed engineer turned lawyer. So I actually think that the engineers turned lawyers are some of the most dynamic and strategic thinkers that we have in nuclear law. So number one, I would absolutely encourage it. Number two, at least speaking from a US perspective, unfortunately, turning into a nuclear lawyer entails going back to school for 3 years to get your Juris Doctor degree. Now, in other European countries, you don't necessarily have to get a JD. You can do a pathway with an LLM to practice law. You don't necessarily have to go through that huge undertaking of getting a true JD degree. So you'll have to look at your own country to figure out what the requirements are to switch over to a career in law. But I would say, kind of dip your toes in, doing what you're doing right now, finding out what exactly does a nuclear lawyer do. Hopefully WiNLI will have maybe a webinar in the future about, practically what is it that a nuclear lawyer does, and those types of things might help you to see. But come to the ISNL, come to the INLE. We are obviously working within our global forum on reestablishing nuclear law education. We're trying to promote LLM programs, particularly in energy and environmental law, to incorporate nuclear energy into their teachings, but you don't have to go to get an LLM in nuclear. Basically, you need to get an LLM or some kind of degree or certificate or something in your country that allows you to practice as a lawyer, and then you enter generally the career of nuclear. I don't know, Lisa or Perry, if you'd like to add on to that.
I agree 100%. And the only thing I would add is also we have a number of what we have is Nuclear Law Institute here, where it's a 2-week training. It's a little bit different from what Kimberly described, what the ISNL offers. It's targeted towards our member states, and it's about the legislative assistance process. So you'd already have to be in the business with your government for that. But we also have launched a partnership initiative with universities exactly because there's not a lot of teaching on nuclear law. When I was in law school, there was no such thing as nuclear law. It was maybe environmental law. That was a topic. But so for those who are interested in moving from engineering into nuclear law, you could also look at our website and also NEA's website on their partnership initiatives with universities. You might consider those universities because those are universities that are very interested in developing their nuclear law teaching opportunities. So it would be great for students who are interested in that area.
The only thing I would add is that yes, a nuclear law program in law school is pretty hard to find. If I don't think that it exists, but environmental law, energy law, those programs do exist, and they do provide a good basis from which to then go into nuclear law. And I will say some of the offerings, like the Nuclear Law Bulletin, which is free and online, they're fabulous offerings for anyone who's looking to dig in to real issues of nuclear law as experienced by the members themselves.
Fantastic. I want to thank all of the panelists for their wonderful presentations and the very insightful discussion we just had. Thank you once again. Thank you to the audience for joining. This ends the first Women in Nuclear Law Initiative webinar. I want to thank everyone again for joining and for valuable participation. And we hope to see you again at our next webinar, which will be announced very soon on the NEA website. So thank you.
Thanks, everybody.
Thanks all. Bye now.